We're live.
Thank you. Good morning and welcome to Senate Judiciary. Today is Wednesday, January 29th. We have an agenda which we'll be following. We're going to start with S9, which is an act relating to after hours access to orders against sexual assault. And we'll start off with Ledge Council if you want to walk to.
Good morning. For the record, Michelle Childs, Office of Legislative Counsel, and as the Vice Chair, so we're taking out S9 is introduced. I'm also going to pass out to the committee members a copy of the chapter for orders against stalking and sexual assault. I think it'll just be helpful to give you some context. Actually, I remember being in this committee, this is, I'm pretty sure that this is where the bill started. This chapter was enacted in 2006. I remember working with Lee Suskin when he was the court administrator, and we had worked closely on kind of developing this process. And the idea behind this is, so when you think about, let's look at our RFAs in Title 15. So when there's domestic relations, right? And I think you folks are pretty familiar with that with regard to people being able to obtain a civil protection order in cases of domestic abuse. And so the Title 15 procedures, remember what you have there is you have the criminal law, let's say in the context of domestic assault, right, which is in Title 13, which can go the criminal path. But there's also a civil route. So someone can get an order of civil protection. And so that is issued in the civil division as opposed to the criminal division. There can sometimes be a path where there is a civil process and a relief from abuse order in place at the same time that there is a criminal proceeding moving forward for a domestic assault. But sometimes there's one or the other. Sometimes there is a criminal action and someone chooses not to petition for an RFA, an order of protection, or vice versa. Sometimes people will get an order of protection and there won't be a criminal case. So what they did back in 2006 was look at, well, what types of situations are there that perhaps aren't addressed by the Title 15 provisions? Because in order to get an RFA under Title 15, it has to involve a family or a household member. Okay, so family being just what you would think it would be. Household member is pretty broad. So it could be someone who you live with, but it could also be someone who you either have a dating relationship with, or had a dating relationship with, or have a sexual relationship, or had a sexual relationship. So it's pretty broad, but basically there's this connection there. But there are other circumstances where that relationship may not be there. And so that's where I think the Domestic Violence and the Center for Crime Victim Services came to the legislature and said there's a need for orders of civil protection that don't quite fit into the Title 15 context. And so that's what you have in Title 12 here with the orders against stalking or sexual assault. So this was modeled after the same process that you have for the relief from abuse orders and domestic situations. So you have essentially the same process where someone can apply to the court for an ex parte order, an emergency order. So those ex parte orders are ones where the defendant isn't necessarily there because they're done on an emergency basis. So they're trying to get the order of protection in place as soon as possible to protect the petitioner. So ex parte orders are temporary. They last for 10 days, and then there's what is called a year that is set for that. So that initial emergency order is for a very short, limited time period, and then the defendant is provided notice, an opportunity to be heard at the hearing, and can show up at the hearing with regard to the issuance of the final order. So the process is the same. The thing that is being addressed specifically in S9 is how do you obtain those orders if it's at nighttime, if it's on the weekend? There is a process that's in place now for folks to be able to obtain emergency orders under the Title 15 provisions on nights and weekends, but there is not a similar process for the civil orders of protection in the context of stalking or sexual assault.
Did we make that civil change recently? Or I'm just remembering,
On the getting them nights and weekends? Not, it's not.
because I remember
I'd have to
we
look
talked
and see.
about this issue. And Judge Zone mentioned that we had, Judiciary had been taking up similar thing about what to do when the office is closed.
I believe that was with Tom Zonay, Chief Superior Judge. I believe that was with emergency risk protection orders, which were added after hours.
That's right. Thank you, Judge.
So I just want to kind of give you the context of the area of law that we're working in. If I turn your attention, so that's why I gave you copies of them after there. And at some point, if you want to kind of go into those elements there, but you can see for yourself in there the definitions, what sexually assaulted the plaintiff means. It doesn't just mean the offense of sexual assault. So it's a little broader than that, covering other sexual conduct. Remember that when we're talking about the civil orders of protection, it's a different standard than if you're a criminal court. So it's preponderance of the evidence is what has to be presented to the court, and they have to find that the person has sexually assaulted or stalked the person, and it's preponderance of the evidence standard as opposed to beyond a reasonable doubt. So turning to the language in S9, so these changes with regard to after regular court hours, it's only applying to the orders with respect to orders against sexual assault. It's not applying to the stalking orders. And we've got some great witnesses who are going to follow me. And this was part of, I think, an agreement and discussion between the various players who would be working in this area to look to kind of focus it on these particular orders. So if you look at the language in section 1, so it's amending subsection B. And again, the language is modeled after what you have for RFAs and domestic abuse cases. So subdivision B2, starting on line 16, is that the court administrators to establish procedures to ensure orders against sexual assault after regular court hours. Designating that the court's to designate an authorized person to receive the request for the emergency relief. Subdivision 2B on page 2, just identifying that they can do it through an electronic submission if it's appropriate under the circumstances. Subdivision C is with regard to the affidavits that are submitted in support of the petition. So affidavit has to be sworn to or affirmed by oath over the telephone to the applicant by the authorized person. And there's a certain statement that they have to attest to. Subdivision D is that the authorized person is to communicate the contents of the complaint and the affidavit to the judicial officer who's going to be considering whether or not to issue the emergency order. The judicial officer is to issue the order solely on the basis of the contents of the affidavits provided. So it could be the complainant, there could be perhaps law enforcement was involved. It could be an affidavit from a law enforcement officer.
Mr. Vice Chair.
Yes.
So, am I understanding it correctly that the complainant contacts the authorized person contacts the judge, so they remain a go-between throughout?
Right.
Okay.
Yep. And I'm sure Judge Zonay can talk to you a little bit more about the little details. Yes.
Okay.
Let's see. And if the order is issued, then it's delivered to the appropriate law enforcement agency for service and to the polling station. So that would be that. So remember, in these cases, it could be that there's an incident on the weekend or late at night. Someone is seeking a civil protection order. The defendant, the person who's going to be subject to the order, is not there. So we want to make sure that that order goes out and that person is served with the order as soon as possible.
And the effective date is pushed out a little bit to allow.
Right, I just picked that because, you know, lots of times when you guys are kind of setting something up with the courts, and you want to give them a little extra time to make sure that, you know, get everybody on board, get the forms filled out, figure out who's going to be taking this on in each individual courthouse, things like that. So that's just a little placeholder. You guys can talk with the judge around whether or not that's appropriate timing or whatever, but sometimes you don't want to. Sometimes July 1st is a little too quick, depending on how fast the bill moves.
So I had a quick question. I haven't dealt with these many times. It appears as though this is going to be filed in criminal versus civil.
No, this is civil.
Oh, this is civil.
This is civil.
So the procedure in itself hasn't changed at all as far as protection of those individuals who may be coming to, not the alleged victims, but the workers who process this. Is this something that they're going to do over the phone, or is it they're going to come to the police stations for their safety, so on and so forth, or do you know what that, maybe the judge can respond to that.
Yeah, you mean who's going to provide service to the defendant?
When they're filling out the paperwork, filling out their affidavits.
Oh,
Okay.
so when
When the worker is signed work, I don't refer to him or her.
oh, you mean the court
The
personnel?
court person.
Oh, okay. I think that'd be a best conversation.
Okay, so this is civil and not criminal.
Yes, so it's civil in the same way that you have the Title 15 abuse prevention orders. So that are issued for family or household members. So completely separate from the criminal case. There might be one initiated, might not be one initiated, especially in the context of, let's say that there was a sexual assault, right? So let's say law enforcement is called, is investigating, the survivor wants to obtain a civil order of protection immediately, right? In that circumstance, let's say it's on a Friday night, they want to get that in place to feel safe. You know, based on the law enforcement officer's investigation, you know, it may be some time before a criminal charge is filed, or if at all, but you can still have the civil order of protection independent of the criminal proceeding.
Okay. Any further questions? Thank you. Having said that, I'll turn the gavel over to Mayor Hashim.
Thank you, Senator Norris, and apologies for running behind. I had some work to take care of. I take it that we're wrapping up the walkthrough.
Yes, but I guess my quick run through was just, this has been around for almost 20 years. Started in this committee, created in this committee, and in cooperation with the court administrator at the time. And it's modeled after the Title 15 RFAs for abuse prevention. So the process is the same. Standards are the same in terms of there's its preponderance of the evidence. There's ability to obtain an emergency ex parte order, and then you go on to the final order. Timing is the same. The difference here is that there is not a process for after regular court hours for obtaining these civil protection orders like there are for the family and household member abuse prevention orders. And S9, even though it's amending the chapter that provides for the ability to get orders against stalking and sexual assault, this provision with the after orders is only applying to orders against sexual assault. Doesn't include the stalking orders.
It doesn't include the stalking orders for
the after hours. Yep.
Okay.
And I'm sticking around, so.
Just saying.
Yes.
See that next up we have Judge Donnich.
Good morning. Morning. Tom Zonay, Chief Superior Judge. So I agree with what Ms. Child said. That is that essentially what S9 does is it takes the civil sexual assault component of Title 12 proceedings and makes it online with the after hours procedures from Title 15 for relief from abuse orders. And the language in S9 mirrors that from the Title 15, Section 1106. The only language suggestion I would have would be on line 20. It says for emergency ex parte relief orders submitted, I would put the words against sexual assault right there, just to make it very clear, because subsequently it talks about 5134.
Yeah.
And I want to make it clear that there's a difference between the sexual assault and the stalking. So that it's very clear this applies to sexual assault. The court currently has after-hours procedures in place for relief of abuse orders. They added, based upon the legislature's adopting the provisions allowing after-hours for emergency risk protection orders, that was added to the after-hours work. And so this would also go into that same process that we already have in place. When that happens with ERBOs, there's a question about the union, a side letter of agreement, and that took a little bit of time. And so I think the delayed September 1st works nicely to give the court time to do that. As far as this type of bill, it clearly provides a protection for individuals who would not be entitled to it now. The example that was given when we were discussing this, and it was brought to my attention, would be the college student, unfortunately, let's say at UVM, who had an event that was a sexual assault. They should be able to get relief on a Friday night, not have to wait till Monday morning. And so we have a process. In 2024, up until December 12th, I believe, was the date I ran the numbers. I think we had 32 sexual assault petitions filed. So this is something that I believe we can absorb in the judiciary. The impact is one that is something that we certainly can address. I cannot identify any specific financial budgetary impacts at this time. Is it possible that the union may say, well, we have to pay more on call money because these were added? That is possible, but I can't say that's going to happen. And my thought would be that if that did happen, and we believed it was a cost that we needed to get additional budgetary funds for, we'd come back next year or the year after if that happened. But right now, again, there was 32 across the state last year. So I do not anticipate, the trial court operations does not anticipate that this is going to be a significant burden. And certainly the benefit to the individual seeking protection is one that is important.
Yes.
I'm just wondering if you could walk us through the thinking on not including stalking, and why you're differentiating.
When the network first mentioned this, my understanding was they were seeking for sexual assault. The network was not advocating at that time. I'll let Charlie speak to that, but I don't recall them saying, oh, we want stalking too. In 2024, as of December 12th, I believe we had 1,293 stalking petitions. Stalking petitions are oftentimes derived, as one judge said, I testified, I think last year, the year before, this very room. One judge noted it sometimes can be, for using UVM as the epicenter, two college students are upset with each other, posting things online. And so one said, and the police, they say to the police, well, they said this, and the police say, well, you should go get a stalking order. There are frequent neighbor disputes. They're plowing in my driveway, they're watching me, things like that. Are there other more serious events that are for which petitions for stalking are sought? Yes, absolutely. But we have a significant number of disputes that come to the courts for which temporary orders are not granted. If stalking were added to this, that would have a definitive financial impact. It would have budgetary issues, and it would have significant numbers coming at night. I have no doubt about that.
Thank you.
Senator Bowles.
Yeah, I'm just wondering, and maybe the network is actually the better person to ask, but I'm curious in terms of stalking, what percentage of those escalate into violence or escalate into just escalated interaction? Because I know that in many instances, stalking can be sort of a first step towards something else.
Absolutely. And certainly if individuals have conduct, there is the legislature enacted criminal stalking statutes. So if it's a Friday night and someone believes that they're being stalked, they have the ability to contact law enforcement for immediate action to address that. And it's also important to keep in mind that when we talk about stalking, the fact that stalking in the civil context for individuals who don't know each other, who are not family or household members, the fact that you can't file after hours there does not have any impact on the ability of individuals who are family or household members as defined to apply for a stalking order.
Right.
In other words, if there is a former relationship, a boyfriend, girlfriend, they fall under the relief from abuse protections of Title 15. That's 24 hours a day. They can, that individual can file for protection there. And one of the claims that you can file, one of the causes of action, if you will, is stalking. That relates back to Title 15 definitions, but it can be pursued at any time.
That's helpful, and I still sort of sit with concern, and I had this concern last year or the year before, which is why I asked us to revisit the stalking statutes about instances where that relational background can't be proven and there is still danger involved.
And yes, and that certainly is a policy decision for the legislature, but there is a stalking criminal statute that if law enforcement is involved and contacted at night, they certainly can take appropriate action based upon the criminal statutes. If they make an arrest, they then can get conditions of release, which can address protection issues for those types of cases.
Any further questions? Any further testimony?
No, if you have any additional questions as the bill develops, please don't hesitate to let me know.
Don't believe I have any questions, so thank you, Judge.
Thank you. Thank you, Judge.
Next up, we have Carly.
Good morning, Carly Lesserman, Policy Director at the Vermont Network Against Domestic and Sexual Violence. On behalf of the network and our 50-member organizations, I am pleased to testify in support of S9 today. Sexual assault protection orders are a critical legal tool for survivors of sexual violence, and when survivors can only request protection orders during regular court hours, it leaves them at risk during evenings, weekends, and holidays when emergencies happen. As Judge Zone said, the lack of after-hours access to sexual assault orders is particularly concerning in environments where a survivor is in close proximity to a perpetrator, like an apartment building or a college campus. Advocates and our member organizations who provide 24/7 support to survivors consistently report that survivors' safety is compromised when they cannot seek a sexual assault protection order after hours. One account from our members, Atria Collective, a member organization serving survivors in Addison County, was called to a hospital for a sexual assault nurse examination early on a Friday evening after a survivor was sexually assaulted by an acquaintance. An advocate supported the survivor through the exam and safety planning, and as part of the safety plan, they identified that the survivor wanted to apply for a sexual assault protection order because the perpetrator knew where she lived and other details about her life. The survivor was assaulted on Friday evening, so the court was already closed for the day, and she could not file a protection order until Monday morning. This left a dangerous gap in her safety plan for multiple days after the assault, when she did not have legal protection to prohibit the perpetrator from returning to her home or her place of work. Survivors like Atria's client should have access to protective measures when they need them, and that is why we are strongly supportive of S9. Thank you for the opportunity to testify. I'd be happy to answer any questions.
Yeah, it's the same question. I'm wondering if the network has any data or information around stalking and when that escalates to violence, and if there's a percentage of time that happens within relationships under that legal definition or outside of the.
It's a good question. I don't have any kind of information on that offhand right now, but I'd be happy to look into it and follow up.
Awesome, thank you. One of the places I'm particularly aware, just due to my own experiences and due to sort of the world in which we now find ourselves living in, of an instance where stalking can be problematic and could easily, I think, escalate into violence, but wouldn't meet the criteria of a family relationship is around elected officials and public servants. And I just think it's worth being aware of. I think that, we're seeing escalating violence and we're seeing so that is one area that I think for the committee's sake, I don't know that it's necessarily a specific space that the network needs to be digging into the data, but I do think it is important to just be aware that that's the world we live in, and those types of cases do not meet the criteria of a family relationship.
Absolutely. And, our member organizations support survivors of domestic violence, sexual violence, and stalking. It is absolutely something that we see and put attention towards. I think F9 is an opportunity to expand access for protective measures in a way that the judiciary can take on at this time, and we're supportive of that.
Any other questions? Charlie, do you have any additional testimony or any additional recommendations for the language that you'd want to see?
I do not. I think the change that Judge Zone noted is perfectly fine with us, and otherwise language looks good.
That reminds me, I'm glad I asked. Judge Zone, could you just repeat the exact language you would recommend? I didn't.
Line 20,
Yep.
after the word orders, I would just add against sexual assault. And that's consistent with what's just above that in subsection B2.
Thank you.
Great.
Thank you, Charlie.
Thank you.
Next up, we have Laura Beerley. Byerly.
Good morning. Thank you for having me. My name's Laura Byerly, and I'm the director of the Victims' Rights Project of Vermont Legal Aid. Just to echo some of the things that I've said here, providing easy access to protections orders has been a project I've worked on for my entire career. No matter how we've worked to simplify the process, the forms, and access and assistance online, survivors really do struggle to fill these in and ask for the protections that is available to them, especially when many of them are filling them out at the time when they're first dealing with intense trauma. And so this tool allowing a survivor to access protection when they are really most vulnerable and most in need of that protection is really a very important tool. And I think I have one client story that I can share with you that illustrates that. I worked with a survivor who lived in a fairly remote area of Vermont and couldn't get to the courts very easily. And after surviving a sexual assault and then learning that the defendant was getting out of jail, she went to court and she did manage to go down, drive an hour, get to the courts and fill out the paperwork to apply for a protection order. First, she tried to file for an RFA, but it was denied due to a misunderstanding about the relationship between the parties. So she was directed to go to across town to the civil court. So after waiting in family court for hours to get the denial, she packed everything up and went over to civil division and filed for a civil protection order against sexual assault. But then in civil division, her order was denied because she was a family member with the person who assaulted her. And so she ended up spending an entire day going from court to court and filling out form after form and not getting any protection. And it wasn't until the end of the day that she was finally referred to me. And we talked, and I learned enough information to realize that she really did qualify for an relief from abuse order. So thankfully, we had the opportunity and the ability to access the after hours line. It was 7 o'clock at night, and we called together. And I can't tell you how helpful and what a relief the after hours worker was for this client, for this survivor. They helped walk her through the forms. They got the necessary information to lay out the family and household member qualification for an RFA, and she was able to get the protection that she needed. I mean, I, of course, can file for a protection order for a client. But if I had done it, it would have been more delay because I still would have to go get an affidavit from her and I would have had to do more paperwork. And her mental health was really deteriorating at this point, trying to seek some help from the court and getting denied at every turn. But that after hours worker really helped her in a very vulnerable moment and helped walk her through those forms. This is an incredibly important tool for survivors to have. And I thank you for giving me the opportunity just to point that out. And for making this important change. Thank you.
Thank you. Any questions? Right. Well, that leaves us with a whole lot of time. I think I will also reach out to SAs, the defenders, and perhaps law enforcement to see if they want to chime in on this at all. And then we can perhaps put it on the schedule Friday. We have some time there for markup, a possible vote, depending on what we hear from additional witnesses. So I think that in the meantime, we can take a 15-minute break, then we can come back and discuss something. We'll find something.